Journal. Yeah. I just thought we should go through some of the terminology of the domestic violence for Judges 2015. Yeah. That was updated on February 19th of 2016. Yeah. Washington State's Administrative Office of the Courts. Yes. Now, yesterday I was explaining about the different list of current forms. Yeah. Provides for the issuance of two types of orders, the 26.50. Yeah. Ex parte temporary order of protection upon showing of the irreparable injury. Because of the distinguishing characteristics of these orders are not their temporary nature, but the fact they may be issued. Yeah. Ex parte, they will be referred to throughout this chapter as the ex parte orders. Yes. And then there's the RCW 26.50.060. Yes. That provides for the issuance of an order upon notice and after a hearing. Yes. Now, these orders are occasionally referred to as the permanent orders. Yes. Notice and after hearing. Yeah. This is a misnomer. If the order does not restrain the respondent from contacting his or her own child. Yes. And if the court determines the respondent is likely to resume acts of domestic violence when the order expires, the court may issue an indefinite order or a long-term order with a specified expiration date. Yes. In other situations, the order is issued for no more than 1 year. Orders issued following notice and hearing, yes, will be referred to in this manual as final orders. Yes. Now, I just wanted to mention the notice and after hearing. Your exception to the rule of the yeah. See, the issuance of an order upon notice and after hearing. They say that they are often referred to as permanent orders. Yes. This is a misnomer. Yes. If the court determines that the respondent, yep, likely to resume acts of domestic violence when the order expires. Yep. If the order does not restrain contact in a trial, if the court determines respondent likely, the court can issue an indefinite order for a longer term order, 10 years. Yes. 2 years. But in other situations, the order is issued for no more than 1 year. Orders issued following notice and hearing will be referred to in this manual as final orders. Yes. See, one of the things you didn't do as a court, you did know where I was at. I was there from March of 2012 to December of 2012. Yes. I was at my grandmother's from December of 2012 until February of 2013. Yes. I was at the Serenity House from approximately April of 2013 until May, June, and July of 2013. Now, the statutory authority. Oh, we tried to serve him, but we couldn't find him. Oh, mandatory forms. Yes. Those 5 minors named. Oh, the require of notice and hearing. Yes. Now, the protection or listing of the current forms, filing deadlines, and the statutes of limitation. Must file for protection order. She could have filed at any time. Did she say for 10 years of marriage? Recent acts of domestic violence are not required in order to obtain or renew a domestic violence protection order. The petitioner must only show present fear of harm based on past violence or threats of violence. Yes. Spence versus Kaminsky. Muma versus Muma. Barber versus Barber. Yes. The issue is the issuance. The Court of Appeals uphold the issuance of a protection order where the petitioner did not allege a recent overt act of domestic violence. Yes. The petitioner, who had been victimized by the respondent for a period of years, was granted the order based on her current fears, even though most of the overt acts of domestic violence occurred 5 years before the filing of the petition. Yes. Now let's talk about my wife's fears and what actually took place on Guam. You did get the police report from Guam? Yeah. hmm And you did get the stipulation and order from Guam? And you got the expungement order from Guam? You know, this idea that there is this fear of being victimized, yes, for 8 years, 4 months, and 10 days. Right! This fear, yes, that the actual act never took place in the state of Washington. The fear that I'm going to victimize my wife as what she experienced on Guam. There's a problem with no one in law. You know, if she wanted a protection order from Guam while the stipulation and order was in place, yeah, they probably would have considered that. Oot. But you, well, grounds for the issuance of a domestic violence protection order. Yeah. Physical harm, bodily injury, assault, or the infliction of fear of imminent sexual assault, stalking, harassment. Definition of harassment. Yes. Exactly. Where did a final order of protection can be issued without a showing of a recent overt act? Yes. Of domestic violence, as so long as the victim, based on prior acts of domestic violence, yes, remains in fear of the respondent. In contrast, an ex parte order cannot be issued unless there is a danger of the irreparable injury to the petitioner, which would have generally required a recent act. Yes, comparing RCW 26.50.060 and RCW 26.50.070. Now, the comparison, the definition of domestic violence. Now, since I never talked to my wife, yes, I did see her a couple times and I did leave. Yes, anytime I did see her. Exactly what fear do we need to get out the protection order again where it says respondent shall leave if they are both at the same location? Prosecutions for acts of malicious mischief, criminal trespass, burglary, kidnapping, child abuse, child neglect. Yes. My son's being in the wrong grades. The son's family or household member may apply for a protection order. Yes. Yes, yes. Spouses, former spouses, persons who have a child in common. Yes. Related by blood or marriage. So, dating relationships. Yes. The No, I want you to understand something. Yes. You're going to prison. No, I want you to understand. You're going to prison. My wife had you issue a protection order in 2011. Yes, where the actual arrest took place on Guam. The judiciary of Guam had the jurisdiction for the issuance of any protection order. Yes. When I moved back here, yes, I was on probation. You falsely accused me of violating it in 2012, 3 days after she petitioned the court for dissolution of marriage. You, as a court, tried me for the same offense twice. Yes. Once while I was on trial. Yes. And once by minute order. Now, the justification for right now, you're going to prison. For the reissuance of the protection order for 1 year. Yes. From June 6th or July 6th of 2012. Was that she was in imminent fear